Welcome to Chapter 6 of Law in Australian Society, which is about human rights protection. In this chapter you'll learn about what human rights are, the lack of human rights protection in the Australian Constitution, and the possibilities for improving human rights protection at the national level in Australia. So what are human rights? Human rights are core protections and freedoms that all human beings should be afforded simply because we're human. This includes the rights to life, liberty, privacy, and the freedoms from slavery, torture, and discrimination. A lot of human rights overlap with things we talked about with liberalism. So civil liberties include things like the rights to liberty, privacy, private property, and things like that too. The difference is we have human rights because we're human, and we have civil liberties because we live under a liberal democratic government. So there is some overlap between them, but human rights extends to lots of other things like freedom from slavery and torture, which we wouldn't normally call civil liberties. One of the first major human rights documents was the 1948 Universal Declaration of Human Rights that was published after the Second World War. And there you can see a list of the major human rights that should be protected. The Australian Constitution is the founding document of our nation, but it makes no reference to human rights. The Constitution does protect a few rights: the right to trial by jury in Section 80, freedom of religion in Section 116, and freedom from discrimination, but only on the basis of state residence in Section 117. If you've seen the movie The Castle, you'll also know that property can only be acquired by the Commonwealth on just terms. The High Court has also implied two rights from other sections of the Constitution: a right to vote and a freedom of political communication. By implying a right, this means that the High Court looks to other sections of the Constitution and interprets the Constitution to provide some rights protection, but the rights aren't explicitly protected. So there are a few rights in the Constitution, but these do not extend to the full gamut of human rights. Where a law is incompatible with the Constitution, the High Court has the power to strike those laws down. This is known as judicial review. However, the High Court cannot strike down a law on the basis that it infringes human rights because the Constitution makes no reference to human rights. The High Court might find some other basis for invalidating the law. For example, it might infringe the separation of powers, but it cannot strike down a law on the grounds that it infringes human rights. Thankfully, there are many other ways that human rights are protected in Australia. The principle of legality is a way that courts interpret statutes or legislation. The principle of legality is a presumption that Parliament did not intend to interfere with rights and freedoms. So wherever a court can interpret legislation in line with human rights, it will do so. The major limitation of this principle is that wherever a Parliament explicitly infringes human rights, well, then there's nothing a court can do. There's also legislation at the federal level, such as the Racial Discrimination Act of 1975, which provides protection for human rights. The difference between this and constitutional protection is that legislation can be amended or suspended. The Australian Human Rights Commission plays an important role in advocacy around human rights and can investigate human rights complaints. In 2011, a Parliamentary Joint Committee on Human Rights was created, which looks at laws going through Parliament to examine whether they are compatible with human rights. And there's also statutory protection for human rights in the ACT, Victoria, and now Queensland, but not at the national level. There are two main ways that we could provide greater protection for human rights at the national level in Australia. The first would be to insert a Bill of Rights into the Constitution. This would require a referendum, meaning that a double majority of the Australian people would need to agree to changing the text of the Constitution. This would provide very strong protection, but it could be very difficult to achieve. The other way to achieve greater protection of human rights would be through a Human Rights Act. This would be federal legislation that protects human rights at the national level. It would be quite similar to the legislation in the ACT, Victoria, and now Queensland. A Human Rights Act would be much easier to enact because Parliament could enact it without going to a referendum, but because of this, and like other human rights legislation, it would also be easier to amend or repeal. So the key points in this chapter are that human rights are core protections and freedoms that every human being should be afforded. There is no constitutional protection of human rights in Australia. There are two ways that human rights protection could be achieved at the national level. This would be a constitutional Bill of Rights, which would require a referendum, or a statutory Human Rights Act, which could be enacted by Parliament. Some discussion questions for your lectures and tutorials. Can you find a copy of the International Human Rights Treaties listed at the beginning of the chapter? Which rights do these treaties protect? The chapter also discusses the difference between civil and political rights and economic, social and cultural rights. Do you think that economic, social and cultural rights should be categorised as human rights? Are they necessary to ensure human dignity in the same way as the right to liberty or the freedoms from slavery and torture? Which rights are protected in the Australian Constitution? And what is an implied right? What is the difference between a Bill of Rights and a Human Rights Act? What are the advantages and disadvantages of the first model compared to the second? And do you think protecting human rights through our democratic and political system without constitutional protection is sufficient?